In this series of lectures on legal profession, our next important item to be discussed in this lecture is regarding rights of advocates. So, Section 29, Section 30, Section 32, Section 34, and Section 34 in Chapter 4 of Advocates Act 1961 enumerated the rights of advocates and the necessary provisions governing such rights. Right to practice is the primary and most fundamental of all the rights entitled to advocates under the Act. According to Section 29, we stipulated that advocates to be the only recognized class of persons entitled to practice the profession of law. So, subsection 1 of Section 39 says that to act for any person in any court, an advocate should be duly appointed by such or by his recognized agent or by person duly authorized by power of attorney, and such appointment should be a document in writing and signed called Vakalatnama. And subsection 2 of section 29 provides that all such appointments shall be filed in court with them to be in force until the client or the pleader dies or until all proceedings in the suit are ended. Proceedings in the suit means any application for review of the decree or order or an appeal from any decree or order or any application for the purpose of obtaining copies of documents or return of document produced or refund of money is paid into the court in connection with the suit. Subsection 3 of Section 29 entitles the High Courts to give necessary direction to any advocate in appointment of a pleader to obtain the attestation of necessary marks in the prescribed manner where the client is unable to write his name. And according to the provisions of subsection 4 of section 29, a pleader has to file a memorandum of appearance signed by himself stating the names of the parties to the suit, the name of the party for whom he appears, and the name of the person by whom he is authorized to appear. Further, this section provides different rules on different nature in pleading. When a pleader is appointed by a party to act in court, the appointment must be in writing by a document called Vakalatnama. In case engaged by a party for pleading only, the requirement is to file a memorandum containing the particulars mentioned in subsection 4 of section 29. In case engaged to plead by a pleader duly appointed by the party to act, filing of memorandum is not necessary. So, in that connection, would like to discuss a landmark judgment of the Jammu Kashmir High Court in the leading case Hare Krishna versus Tilak Rai in 1972, where the Honorable Court held that the only manner in which the authority of a pleader can be brought to the notice of the court is by filing the Vakalatnama under Order 3, Rule 4, read with Rule 1 of the Civil Procedure Code 1908. When such a Vakalatnama is filed in court, Without the signature of the pleader, the defect can be cured. Why the pleader signing the Vakalatnama in court on taking court's permission? And in that connection, we would like to discuss the provisions of Section 30 of the Advocates Act 1961, and this very section came into force on 1st June 1969, which provided that every advocate, the name entered in the state roll, is entitled to practice throughout the territory to which this act extends in all courts including Supreme Court, before any tribunal or person legally authorized to take evidence. Advocates entitled to practice before any other authority or person. While Section 33 provides advocates alone entitled to practice unless enrolled as an advocate under this Act, while Section 33 provides that only the court, authority, or person may permit any person, even though not enrolled as an advocate under this Act, to plead before a court or a presiding officer, even before a tribunal or any person legally authorized to take evidence, while Section 34 of Advocates Act provides the power of High Court to make rules laying down conditions to which an advocate shall be permitted to practice in the High Court or the subordinate courts under its jurisdiction. And all this relates to rights of advocates. And besides that, we found a very difference between a pleader. A pleader appointed by a party to act in the court appointment must, under a Vakalatnama and filed in court, engaged by a party for pleading only shall file a memorandum containing the particulars as provided under subsection 5 of section 29, and also would be engaged to plead by a pleader duly appointed by party to act. The memorandum is not necessary here. So in that connection, we would like to discuss important leading case, Harishankar versus Girdhari in 1978. The Supreme Court expressed that a private person who is not an advocate has the right to argue for a party. He must get the prior permission of the court. So, as per the provisions of section 29, as that advocates alone entitled to practice as provided, it could be changed by the High Court by permitting any person to appear in the court for a client, and that also himself, but it would take prior permission from the court. And this particular provision, as we found under Chapter 4 of the Advocates Act 1961. And now, besides the above rights provided to the advocates under the Advocates Act 1961, a rule made by the Bar Council of India in 1979 that is also important in the connection of rights of advocates. So, the very rule is the advocates' right to take up law teaching rules of 1979. So, in exercise of Section 49 of the Act, and practicing advocate may take up teaching of law in any educational institution affiliated to a university within the meaning of the University Grant Commissions Act of 1956 so long as the hours do not exceed 3 hours in a day and it to be a part-time employment, irrespective of the manner in which such employment is described or the remuneration receivable by the advocate for such employment. So, these are the important rights provided by the Advocates Act 1961 and also the rule made by the Bar Council of India in exercise of its rule-making power under Section 49 regarding that particular rule, the advocate's right to take up law teaching rules of 1979. So in this lecture we have completed those rights of advocates as available under the Advocates Act 1961 under Section 29, Section 30, Section 32, Section 33 and Section 34 under Chapter 4 of the Advocates Act 1961, and besides that also we have discussed regarding the very rule made by the Bar Council of India under its rule-making power as per Section 49, the advocate's right to take up law teaching rules 1979.